Middlesex Mediation is a dispute resolution firm which serves business and business people. Its services include the range of dispute resolution options, which have proven to be at least 90% effective in resolving commercial disputes before trial. Mediation is the process that is generally chosen as the most expeditious and least expensive option involving the participation of a third party, who is described as a neutral. Mediators serve as unbiased neutrals, preserving confidentiality of information and exploring common ground that can result in agreement. Mediation is confidential, cannot be the subject of evidence in an underlying lawsuit, and can be ended at any time by the choice of any party. Middlesex mediators understand the necessity of having sufficient facts available to trial counsel before entering mediation or any dispute resolution process. We will tell you if we believe a matter is not ripe for mediation. Conciliation is another kind of dispute resolution process, which exploits the opportunity for early resolution of complex disputes. In the commercial context, our neutral can serve as a conciliator or facilitator and work primarily with counsel representing the parties to explore the circumstances and challenges of an active legal dispute. The process often enables parties, with the conciliator's help, to manage and resolve a business dispute on their own. Arbitration begins to look most like a litigation process, but it usually remains private, less expensive, and more expeditious. In arbitration, our neutral assumes the role of a judge, and the proceeding becomes more like a private litigation. The arbitrator typically hears witnesses and arguments of counsel and ultimately makes findings much like a court would. Courts ordinarily do not have a legal basis to revise or modify the arbitrator's award or to challenge the arbitrator's fact-finding or legal conclusions. A case evaluation is a different device to help parties see their respective positions more realistically against the risks of trial. As a case evaluator, our neutral learns the factual and legal aspects of a dispute, often conveying an outcome prediction. A case evaluator often assigns success percentages to each side or to claim success, usually accompanied by a thoughtful analysis of the facts and the law. An effective evaluation helps stimulate further negotiation and settlement. The foregoing dispute resolution procedures do not get triggered automatically. Somebody must get the dispute resolution discussions moving. Middlesex Mediation can and does serve as the invitational source for all these ADR options. Often, the early intervention of a neutral for a preliminary discussion with the parties can result in their formulation of the right program to bring the dispute to a negotiated resolution. The Middlesex panel of neutrals includes nationally recognized lawyers from both Boston-based and international law firms. All panel members have extensive careers as business litigators, trial lawyers, or counsel in dispute resolution proceedings serving business, academic, or charitable corporations. And on behalf of all corporate constituencies, including shareholders, employees, and officers. They know the benefits of early settlement and the challenges of maneuvering an active litigation matter toward resolution. Several of our neutrals have had significant experience with disputes involving nonprofits and educational institutions, including student abuse, academic discipline, and discrimination. Based on their careers serving businesses in complex and sensitive matters, Middlesex neutrals understand successful resolution techniques and will earn your confidence managing difficult disputes to satisfactory conclusions. Reach Middlesex Mediation at middlesexmediation.com.